Hello and welcome to Sexual Harassment Prevention Training. This content is provided by the state of Illinois for all employees. My name is Marcia Hokinson and I'm with U.S. Prevent Harassment, dedicated to ensuring a workplace free of harassment and bullying. Before we get started, a bit of information about the training process. This video includes content that's provided by the state of Illinois, and it is specifically about sexual harassment, but we wanted to put it into our format so we could include various other elements. So this session A includes a video, which is rather short, about 30 minutes, as well as a final activity, which takes about 15 minutes, and then a certification test, which should take an additional 10 minutes. We will provide you with codes midway through the session as well as at the end to demonstrate that you have watched the entire video. Also, managers, supervisors, and team leaders should also watch session B to make sure that we're consistent across the board with our multi-state operations. Sexual harassment is prohibited in the state of Illinois. The Illinois Human Rights Act makes it a civil rights violation for any employer, employee, agent of any employer, employment agency, or labor organization to engage in sexual harassment. The Illinois General Assembly finds that tolerance of sexual harassment has a detrimental influence in workplaces by creating a hostile work environment for employees, reducing productivity, and increasing legal liability. The state of Illinois encourages employers to adopt and actively implement policies to ensure their workplaces are safe for employees, to report concerns about sexual harassment without fear of retaliation, loss of status, or loss of promotional opportunities. Employers are required to provide sexual harassment prevention training for all employees. Every employer in the state of Illinois is required to provide employees with sexual harassment prevention training that complies with Section 2-109 of the Illinois Human Rights Act. All employees, regardless of their status, that is short-term, part-term, or intern, must be trained. If an employer has an independent contractor working on site with the employer's staff, the independent contractor should receive sexual harassment prevention training as well. In this training class, this is the information that will be covered. First of all, an explanation of sexual harassment consistent with the Illinois Human Rights Act. Secondly, examples of conduct that may constitute unlawful sexual harassment. Third, we'll talk about a summary of federal and state statutory laws concerning sexual harassment, including remedies available to victims. And fourth, we'll talk about a summary of employer responsibilities in the prevention, investigation, and corrective action measures of sexual harassment. What is sexual harassment? Under the Illinois Human Rights Act, sexual harassment means any unwelcome sexual advances, requests for sexual favors, or any conduct of a sexual nature, when A, submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, B, submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual, or C, such conduct has a purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. There are two types of unlawful sexual harassment. First of all, there's quid pro quo sexual harassment, which is saying something like, you do something for me, and I'll do something for you. This means that a manager or supervisor may not tell an employee that in order to receive a promotion, raise, preferred assignment, or other type of job benefit, or to avoid something negative like discipline or an unpleasant assignment, the employee must do something sexual in return. Secondly, there's hostile work environment sexual harassment, where the air at work is full of sexual references and it is impacting me. A hostile work environment may occur when unwelcome sexual advances, requests for sexual favors, or any conduct of a sexual nature has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Unwelcome behavior. Sexual conduct becomes sexual harassment when the behavior is unwelcome. Behavior may be unwelcome in the sense that the victim did not solicit or invite it, or in the sense that the victim regarded the conduct as undesirable or offensive. Welcome behavior can quickly become unwelcome behavior. What starts off as welcome behavior, such as consensual joking, can cross a line and become unwelcome behavior. Also, consent can be revoked at any time. When someone experiencing sexual harassment behavior says, "Stop talking to me like this," it must stop. The perpetrator cannot use as a defense, "Well, you started it," or "You were okay with it at first." Working environment and non-employees. An employee's working environment is not limited to the physical location where the employee is assigned. The working environment extends to other work sites, including off-site, mobile, or moving work sites and locations. The prohibition that supervisors and coworkers not engage in sexual harassment now applies to non-employees, such as patrons, vendors, and service providers. Non-employees can be victims of sexual harassment and/or perpetrators of sexual harassment. Gender identity, sexual orientation, and third parties and bystanders. All persons can be victims of sexual harassment regardless of the victim's gender identity or the perpetrator's gender identity. All persons can be victims of sexual harassment regardless of the victim's sexual orientation or the perpetrator's sexual orientation. Victims of sexual harassment can include not only the target of the sexual harassment, but also third parties or bystanders. So that covered an explanation of sexual harassment. Now we'll talk about examples of conduct which may constitute unlawful sexual harassment. What are examples of inappropriate conduct? Sexual harassment includes unwelcome conduct of a sexual nature, such as sexual advances and requests for sexual favors. Here are some examples: pressure for sexual favors or to go out on a date, deliberate touching, leaning over, or cornering another person, sexual looks or gestures or whistling at someone, sending letters, telephone calls, emails, texts, or other materials of a sexual nature, sexual teasing, jokes, remarks, or questions, or referring to another as a girl, hunk, doll, babe, honey, tootsie, etc. Actual or attempted rape or sexual assault. Here are more examples of conduct that may constitute sexual harassment: turning work discussions to sexual topics, asking about sexual fantasies, preferences, or history, sexual comments, sexual innuendos, or sexual stories, sexual comments about a person's clothing, body, or looks, kissing sounds, howling, and smacking lips, telling lies or spreading rumors about a person's sex life, massaging someone's neck, shoulders, touching another person such as their clothing, hair, or body. Sexual harassment is also in online environments. Our conduct online and through social media can constitute sexual harassment, even when it occurs off the clock, off-site, or even out of the state. Online sexual harassment includes using email, cell phone text, internet postings, online comments, blog posts, and social media such as Facebook, Twitter, LinkedIn, Instagram, YouTube, Snapchat, to send communications of a sexual nature. Examples include flirting and requests or demands to go on a date or have sex, sending inappropriate pictures or videos including sexually graphic materials, using sexual language or comments including sexually offensive language, or cyberstalking. We've reached the middle of the session, and what we'd like you to do is write this code down. This code will appear on the certification test. The code is CILRV. Okay, we've covered the examples of conduct that may constitute unlawful sexual harassment. Now let's get into a summary of the federal and state statutory laws concerning sexual harassment, including remedies available to victims. What can I do if I experience, witness, or become aware of unwelcome sexual conduct? If this happens to you, there's a couple things you should keep in mind. First of all, you have the right to tell the person to stop. The initiating and participating persons must stop the unwelcome behavior upon request. If they continue the behavior or retaliate against you because you ask them to stop, they can be found to have violated the law by engaging in sexual harassment or retaliation. Also, you have the right to report the sexual harassment. Several reporting options are available. The option you choose may depend on the nature and severity of the unwelcome conduct of a sexual nature. Persons who report sexual harassment or participate in investigations are protected from retaliation. You have several options available to you for reporting sexual harassment. The choice of how to report an allegation of sexual harassment is a personal one, and these options are not mutually exclusive. You may pursue one or more of the following reporting options. Number one, you can call the State of Illinois Sexual Harassment and Discrimination Helpline. Number two, you could report the incident to your employer. Number three, you could file a charge with the Illinois Department of Human Rights, the IDHR. Or four, you could file a charge with the U.S. Equal Employment Opportunity Commission, the EEOC. And all that contact information is provided on this slide as well as on your employment posters. Let's go through those four options so you understand how to report sexual harassment. If you wanted to call the State of Illinois Sexual Harassment and Discrimination Helpline, you could do so. If you or someone you know has experienced or witnessed unwelcome conduct of a sexual nature in the workplace, the phone number is 1-877-236-7703. You could also visit the website at www.illinois.gov/sexual harassment. Calls are confidential and can be made anonymously. Helpline representatives can help callers navigate their numerous reporting options and share additional information related to counseling, legal assistance, and frequently asked questions. Secondly, you could report the incident to your employer. Now, every employer has their own complaint handling procedure, and you should follow that. Your complaint handling procedure will have multiple avenues of complaint available to you, but you could certainly go to your supervisor or any member of management you trust. Supervisors and members of management are responsible for knowing the employer's internal complaint investigation and resolution process, and supervisors can help effect immediate positive change. Secondly, you could go to the Human Resources Officer. They can work with management to investigate and resolve sexual harassment complaints. This option may be preferred if the perpetrator of the sexual harassment is a supervisor or manager. Now let's talk about how to file a charge with the Illinois Department of Human Rights. The Illinois Department of Human Rights, or the IDHR, is a state agency responsible for enforcing the Illinois Human Rights Act, the state law which makes it illegal to engage in sexual harassment or retaliation. Complainants, that is, victims of sexual harassment, may file a charge at any time within 300 days of the incidents. The IDHR has jurisdiction or authority to investigate employers who have one or more employees. To start the process, submit a complainant information sheet to IDHR. After IDHR completes its investigation, the complainant or the employee may file a lawsuit in civil court or may file a complaint with the Illinois Human Rights Commission if the IDHR found substantial evidence of a violation. Complainants who prevail in the HRC or court may receive an order awarding remedies allowed by the Illinois Human Rights Act to make the complainant whole. Remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, and attorney's fees and costs. To file a charge with the IDHR, call them or visit them online. Their phone number is 1-800-662-3942, or you can visit them online at www.illinois.gov/DHR. There's several DHR office locations, and the information is listed on this slide. There are 3 offices, one in Chicago, one in Springfield, and one in Marion. The fourth way you can report sexual harassment is to file a charge with the United States Equal Employment Opportunity Commission, or the EEOC. Let's talk about that process. The United States Equal Employment Opportunity Commission, or the EEOC, is responsible for enforcing Title VII of the Civil Rights Act of 1964, which is the federal law that makes it illegal to engage in sexual harassment or retaliation. Complainants or victims of sexual harassment may file a charge at any time within 300 days of the incidents. The EEOC has jurisdiction or authority to investigate employers who have 15 or more employees. To start the process, call the EEOC or visit their website. After the EEOC completes its investigation, the complainant or the employee may file a lawsuit in federal court. The EEOC may help parties reach a settlement through an informal process called conciliation if the EEOC finds reasonable cause to believe discrimination occurred. Complainants who prevail in federal court may receive an order awarding remedies allowed by Title VII to make the employee whole. Those remedies may include back pay, lost benefits, clearing of a personnel file, damages, hiring, promotion, reinstatement, front pay where reinstatement is not possible, punitive damages, and attorney's fees and costs. To file a charge with the EEOC, call or visit them online. Their phone number is 1-800-669-4000 or 1-800-669-6820 for TTY or deaf or hard of hearing callers. You can also call 1-844-234-5122 for American Sign Language video phone for deaf or hard of hearing callers. Or you can visit them online at the website eeoc.gov. There are 2 U.S. EEOC offices serving Illinois. The first is in Chicago, the second is in St. Louis. All of this contact information can be found at the uspreventharassment.com website under Resources. Now we're into the 4th section, which is a summary of employer responsibilities in the prevention, investigation, and corrective measures of sexual harassment. Is my employer responsible for sexual harassment? Yes, employers are responsible for sexual harassment in 2 ways. First of all, there's manager or supervisor harassment. Employers are strictly liable for sexual harassment perpetrated by its members of management, regardless of whether the employer knew of the harassment. Or there's coworker and non-employee harassment. And employers are liable for sexual harassment perpetrated by an employee, such as a coworker, or a non-employee, like a vendor or a supplier, only if the employer knew or reasonably should have known of the harassment and failed to take prompt corrective action. Now let's discuss employer responsibilities and liabilities concerning incidences of sexual harassment in the workplace, including an employer's responsibility to prevent, investigate, and correct any incidences of sexual harassment in their workplaces. First, let's talk about prevention. An employer's responsibility is to develop, implement, and regularly communicate the employer's sexual harassment policy. Secondly, an employer is responsible for providing training for managers and employees on sexual harassment prevention. Thirdly, an employer is responsible for ensuring clear communication on how to report incidents of sexual harassment or conduct of a sexual nature. Fourth, managers and supervisors should monitor their work environment to ensure the workplace is free of sexual harassment, and supervisors should be aware of the conduct within their supervision. Fifth, managers and supervisors must lead by example and model appropriate conduct, and certainly refrain from engaging in conduct of a sexual nature. And number 6, managers and supervisors should conduct a sexual harassment climate check throughout the year. And here are some ideas. Discuss the topic at a team or staff meeting. Conduct an in-service day or training program as part of a structured communication. Or put it in your division and unit newsletters. Those are all good preventative measures you can take. Now let's talk about the employer's responsibility to conduct investigations. Now, investigations are best handled by a person who has received training in this area, such as an HR professional, a private investigator, or an attorney. But it is the employer's responsibility to ensure that investigations are prompt, honest, and thorough. Here are the steps that should be taken. Immediately, employers should respond to a complaint of sexual harassment and initiate an inquiry or investigation. You should interview the complainant or the victim and take reasonable action to prevent the victim from retaliation or experiencing further sexual harassment during the investigation. Then you should interview all relevant witnesses and interview the alleged perpetrator of the sexual harassment to hear their point of view. Then you should document the investigation results and maintain the file as an employment record. And finally, take corrective action as appropriate. In terms of corrective measures, it's the employer's responsibility to take corrective disciplinary action up to and including termination of employment where organizational policy has been violated. In situations where the conduct in question did not rise to the level of sexual harassment or a violation of policy, but is concerning or may be considered grooming behavior, consider counseling, training, and closer supervision of the employee. Also, take reasonable action within the organization to reduce the likelihood of future sexual harassment incidences by updating policies and communicating them to the workforce, providing supplemental or tailored sexual harassment training, or restructuring the working environment or reporting relationships. And finally, follow up with the complainant or the victim at regular intervals to ensure they and the workplace remains free from sexual harassment. That concludes the Illinois State provided content. We did want to include some more information on big picture items such as federal EEO laws. And remember that sexual harassment is a very important topic, but other forms of harassment are equally as important. So for example, you could be harassed or discriminated against because of your race, color, religion, sex, pregnancy condition, national origin, age, disability, or genetic information. Also, it is illegal to retaliate against a person because he or she complained about discrimination or harassment, or filed a charge of discrimination or harassment, or participated in an employment discrimination investigation or lawsuit. Also, on the state level, there's various protected classes under the Illinois Human Rights Act, and those protected classes are race, color, national origin, religion, sex, including pregnancy, childbirth, and related medical conditions, disability, whether it's physical or mental, age, 40 and above, genetic information, marital status, sexual orientation, citizenship status, military and veteran status, unfavorable military discharge, gender identity, arrest record, victims of domestic violence, status as being under an order of protection, and lack of a permanent mailing address or using the mailing address of a shelter or social services provider. So while the state provided content that we went through specifically addressed sexual harassment, we want you to be aware of your rights under the Illinois Human Rights Act for other protected classes. All of this information can be found on your state poster, as well as the EEO poster, and in your policy manual. So to provide you with some ground rules, here are some case scenarios in the healthcare field. Scenario number 1, joking at work. 2 employees are observed talking in the hallway outside a patient's room. Both are laughing and engaged in the conversation. Employees should be cognizant of their behavior at work. They shouldn't be joking about another person or making comments that demean, embarrass, or offend another employee. And from a customer service standpoint, they should only engage in professional behavior at work, particularly when around others. And obviously, always keep HIPAA confidentiality issues in mind as you are working. Scenario number 2, complaints. An employee has complained about unfair treatment, so the supervisor is unsure how to treat them and ends up avoiding the employee. The answer is the hospital or facility has a complaint handling procedure which should be followed. An employee has the right to complain and should not be treated differently as a result of that complaint. Ignoring or ostracizing the employee or changing the terms or conditions of employment could be considered as retaliation. Scenario number 3, electronic communications. You're friends on Facebook with several other employees, and you notice inappropriate postings about a coworker. The answer is, employees should be careful about their electronic communications on social media like Facebook, Instagram, Snapchat, or others. Disclosing confidential information and communications that are disparaging or disloyal to the employer may certainly be restricted on your social media policies. Scenario number 4, hugging. I'm a hugger, says your coworker, and bestows hugs on patients, coworkers, and anyone else they encounter. The answer is that in healthcare, it's natural to hug patients or coworkers to express sympathy and empathy. In these circumstances, it's likely fine. However, hugging 3 times a day every day may be excessive. Hugging can create a hostile work environment when it is unwelcome and pervasive. Good rules of thumb are, you can probably hug your close friends, but not all the time. You can probably hug someone if you ask and they say it's okay. But you shouldn't hug someone you supervise, and you shouldn't hug a coworker with whom you're romantically involved. Scenario number 5, body language. An employee stares, gives mean looks, or wags their finger and becomes visually angry with her coworkers. Certainly, this type of behavior would not be considered to be professional. Verbal, visual, and physical displays of aggression could create a hostile work environment. Scenario number 6, friendships at work. Your coworkers are friends and end up spending weekends and evenings socializing. Several romantic relationships have resulted on the team. Obviously, it's fine to have friendships with people that you work with. And although we cannot control staff's lawful off-duty conduct, employees should refrain from public displays of affection or excessive socializing. They should also realize that their conduct could be questioned should the behavior come into the workplace. Scenario number 7, dating. An employee asks another employee out and they have said no, but she repeatedly asks them out for a date. The answer is, you spend a lot of time at work, and it's logical that you may meet someone that you want to become romantically involved with. However, if you ask an employee out for a date and they say no, do not repeatedly ask them out. Also, employees that do not report to each other could date, but should be aware that their romance could go sour, so be cautious. Scenario number 8, compliments. A coworker tends to give you compliments on a regular basis, saying things like, "Hey, you look great. Have you been working out?" The answer is that compliments may be misinterpreted due to the tone, content, frequency, and intensity of the attention, among other factors. If the person has said they are uncomfortable being complimented, do not continue this sort of attention. And remember that all workplace communications should be professional. To summarize this section, remember that you have to understand the ground rules of communication and interaction. And the key is to be respectful and professional at all times. Try not to excessively socialize with your coworkers, except for on breaks or after hours. This also applies to your interactions with vendors, suppliers, customers, patients, and management. So to wrap up the training, we're going to ask that you complete a final activity. And that is to take the time to review your state human rights poster, as well as the federal EEO as the law poster. And both of those posters provide details about your rights and responsibilities in the workplace. They also provide information about the contact information for the federal and state agencies that you can call if you have any questions or concerns. These posters are presumably hanging in an area that is frequented by employees. So that would be the break room, the HR department, a supply closet, those sorts of places. So take the time to review those posters and make sure that you understand your rights and responsibilities in the workplace. Now you're ready to take the certification test. And the certification test will include 10 multiple choice questions, and 2 of those questions are regarding the codes. So make sure you have the code from the middle of the session as well as from the end of the session. You need to receive at least 80% correct. You're going to enter your name and your email address, and a certificate of completion will be generated if you are successful. And also this documentation will be retained by your employer. The code for the end of the session is CGILR. So thank you very much, and congratulations for completing the 2020 Annual Sexual Harassment Prevention Training course for Illinois employees. Now, if you're a manager, a supervisor, or a team leader, to be consistent across multi-state operations, we're asking you also to take Session B, and that can be found at the website, which is uspreventharassment.com. Thank you for your participation and for taking this topic seriously. This training class was presented by uspreventharassment.com, dedicated to a professional and respectful workplace. Thank you so much.